Hello aspirants, welcome to PW OnlyIAS. I'm here Harpreet Singh with a daily analysis of the Hindu from 13th of December 2024. This is a Telegram account where you can basically find the particular PDF along with the other material that is required for your preparation. So these are the topics that we have taken for today's analysis. First, Supreme Court halts suits on Places of Worship Act. Next, Disaster Management Bill 2024. Next, Urban local bodies and related issues. Then we have the Vijay Divas. Next, Similipal Tiger Reserve, and then Salar the UANI. Let's see what they are and we'll let's analyze all of them. The main topics. Okay, the topic over here is something that has been in the news continuously. That the issue of Places of Worship Act. So before we analyze what the Honorable Supreme Court has said, we will have to see what the Places of Worship Act is first of all. And then we'll see why Supreme Court halts the suits on the claims over the places of worship. So we'll see this evolution and then analyze it. Let's begin. Okay. See, this is a summary of the Places of Worship Act 1991. See, just to give you a brief background, what happened is, we know historically during the Mughal time also, there are certain evidences that were found based on archaeology and debates that went on in the Supreme Court also, that during the phase of the Mughal rule, some temples were converted into mosques. Now what happened is that because of that, there was a tendency or probability of rift between the Muslim community as well as the Hindu community, because people from the Hindu community might say that this was formerly a temple, right? So in this case, what happened in 1991, the government of India passed an act, Places of Worship Act, where all the structures, whether they were mosque, temples or any other religious structure, at the time of independence shall remain as it is, the nature will not change. In that case, certain exceptions are given, right? Like the Ram Janmabhoomi case and certain aspects that come under the archaeological or the monuments. Certain exceptions are given. Other than that, the nature of the place of worship, whatever it was at the time of independence, shall remain as it is. So having got a brief summary, let's see what the act basically says. Okay. Purpose. The act mandated that religious character of all character of all places of worship must remain as it was on 15th August 1947. That means any temple that formerly was, let us say, something else, supposingly a Hindu temple, formerly was, let us say, a Buddhist temple. That means at the time of independence, it was a Hindu temple, it shall remain the same, remain as it is. If supposingly a mosque, which might have been earlier, let us say a temple, shall remain as a mosque because it was a mosque on 15th of August 1947. So this is what it basically aimed. Now what happens? It prohibits the conversion of any place of worship from one religious denomination to another in a whole or a part. What does it mean? It means that that place of worship, what it was on 15th August 1947, will not be converted into some other place as a whole structure or a part of it. So that means in order to prevent any dispute from arising between the religions because of the places of worship, this act was passed. This was the purpose of it. Now what does it say? Key provisions. Prohibition of conversion under section 3 prevents the conversion of one place of worship, whether full or part. That means if, let us say, a structure is there and one of, let us say it is belonging to religion R1, and religion R2 says, okay, give this part, half part belongs to religion R2 and you have to change the nature, then also it is not allowed. Neither the whole part nor a part of it can be converted. So prevents conversion of a place of worship, whether in full or part, from one religious denomination to another within the same denomination. Right? One more thing, that one religious denomination to another, or let us say there can be various sects within a religion, you cannot convert that also. So this is again a very important provision. Next, maintenance of religious character, section 4, subsection 1, ensures that religious identity of a place of worship shall remain as same as it was on 15th August 1947. So what was the nature of the place of worship, whether belonging to a Hindu temple or a mosque or a Gurudwara, whatever, shall remain as it is what it was on 15th of August 1947. Now, there are certain exceptions under Section 5. Now, Section 5 gives certain exceptions to this particular act. This is important. See, ancient and historical monuments. With respect to ancient and historical monuments, the Act does not apply to monuments, archaeological sites, and remains protected under the Ancient Monuments and Archaeological Sites 1958. An exception was given with respect to the archaeological and historical monuments. Next is settled or resolved disputes. All those disputes which have been resolved will not be again taken into consideration. See, the Act excludes the cases that have already been settled. So those have been settled will not again come into being that there is an issue regarding that. Next, Ram Janmabhoomi Babri Masjid dispute. This case was also excluded from the Act of 1991. That is why we saw the judgment on Ram Janmabhoomi coming in favor of the Ram Mandir, and we saw in the month of January the Ram Mandir was basically inaugurated by the Honorable Prime Minister. Now see, penalties. Specifies penalties including a maximum imprisonment of 3 years and fines if someone violates this act. That means maximum imprisonment of 3 years and a fine can be imposed along with it. Next is bars judicial review. The main criticism of this act was that it bars judicial review. That means the judiciary cannot intervene in this, but this is wrong. We know that judiciary has been intervening in this because the Supreme Court on itself said that no as such law can be excluded from the purview of the Supreme Court or the honorable courts. So now what we have got to know over here, that this act was there and this is what is being debated right now. Now let us see why this particular thing is mentioned over here. Let us see. Supreme Court halts the suits on the claims of places of worship. Now, before I go ahead, first thing what we have done is we have understood what the Act of 1991 is and various provisions. Clear? Now, with respect to this act, Supreme Court had passed certain judgments. Based on the judgments, a series of cases were filed at the local court. We'll see that, and that is why this thing comes into being. Let's see first. First thing is understanding the act that we have done. Then comes the Supreme Court interventions. See, the Supreme Court in the Ayodhya verdict 2019, in 2019 Ayodhya verdict, the Supreme Court upheld. Supreme Court said that, see, we have to uphold the Places of Worship Act 1991, and we are giving the judgment because it, in that case, Ram Janmabhoomi was itself an exception. That is why the Supreme Court had the authority also to give a judgment that in what favor what the structure basically was. So it is not Ram Janmabhoomi verdict of 2019 is not a contradiction of the Places of Worship Act 1991 because we have already seen that this was as an exception already there. Now comes the problem when we see another case being said, how it was misinterpreted by the people also in the lower judiciary. See, Supreme Court in 2023 said, in August 2023, Justice Jiva Chandrachud allowed the Gyan Vapi Mosque survey in Varanasi amidst the claim it was built over a temple. Now, this sparked a debate. Why? Now see, let us understand this. When the word survey is mentioned over, let us see there are a few things. Firstly, let us see from the aspect of the Supreme Court. Supreme Court had said in the 2019 verdict that the judgment given in the case of a Ram Janmabhoomi case was not contradictory to the Act of 1991 because it was an exception. But when another case was filed in the Supreme Court where they said that in the Gyan Vapi Mosque that there a temple used to exist over there based on certain archaeological evidences which the people assume were there, and we want a survey to be carried out in there so that we get to know whether what the actual location where the temple was located. So the Supreme Court said, okay, you can carry on with a survey. Now this led to certain aspects which were assumably contradictory to the Act of 1991. But what the Supreme Court said, see, Supreme Court said that, see, there is an aspect of in the Gyan Vapi, see, in the case of the Gyan Vapi Mosque, Supreme Court is saying, Supreme Court says, we allowed only a survey, right? Justice Diva Chandru said we applied only a survey. Now they said survey is for historical studies, historical and academic knowledge and studies. Historical and academic knowledge and studies. And knowledge is not a contravention of the Act of 1991, because by survey we are not changing the nature. So there the opinion is that by the survey there is no change in the nature or character of the religious place. That means the Supreme Court said that if we are allowing the survey to be carried out in the Gyanvapi mosque, it is not changing the nature, we are just doing for knowledge purpose. But after this, what happened is the various civil courts across the country took it as a guideline from the Supreme Court, and any case that was filed at the level of the civil courts, they allowed surveys of all those mosques. Now see what happened. The lower courts, because of this, what was this? This was a guideline by the Supreme Court. So now the lower courts, that means the civil courts at the district level also, the lower courts took it as a guideline, and they allowed surveys at the local level. Now what happened? When the local courts are saying, okay, if someone files a case that we think that this particular mosque was a temple earlier on, and because of that we want a survey to be done, because the Supreme Court had also given a verdict in favor of the petition where Gyanvapi mosque, where survey was being asked for. So the lower court said, okay, if the Supreme Court can allow that, we can also allow that. So all the lower level, all the mosques that were present in that area, the surveys were permitted. Now because of that, a ripple effect started. Ripple effect means one after the other, local courts started allowing the surveys to be carried on in various mosques. That is why the Sambal mosque case is also one of the examples that came up. And because of that, there was a result of a possibility of a communal disharmony that might rise or increase between the Hindus and the Muslims. So to prevent that, immediately a PIL was filed in the Supreme Court, and they were asked, please take certain action against this, because the lower court are repeatedly asking for or permitting the surveys to be carried out. So in this respect, the Supreme Court said that halt all the claims at the local level where the local courts are allowing any survey to be taking place. So what did the Supreme Court say? See here. The Supreme Court said that civil courts cannot run race with the Supreme Court. That means that when the Supreme Court is right now hearing or the petition with respect to the Act of 1991, and we are dealing with such cases, how is that the local courts are allowing as many number of petitions with respect to survey? So that means it should not be allowed. So that is why what the Supreme Court said, barred the civil courts from registering or passing orders in pending cases seeking to reclaim temples destroyed by the Mughals. So you will not entertain any of these petitions at the local case level. The courts have been directed. Next, one more thing is that meanwhile the Supreme Court agreed to hear petition on the validity of the Act of 1991. So there were other petitions which said that, see, should the Act of 1991 be allowed? Because there are various contraventions that are there. The Supreme Court said, okay, we are ready to debate on the Act, but meanwhile, no other petition shall be filed. So this is what was the particular article that you should be knowing. Let's move ahead. As the case with respect to the validity of Act of 1991 comes, we'll be covering up. Right now, it is under the Supreme Court's jurisdiction. Next. Lok Sabha passes bill to amend the Disaster Management Act of 2005. Now see, we know this becomes important for the perspective that disaster and disaster management topics are very important. So this question can be asked in your GS paper 2 as well as GS paper 3 where environment is there. So you can be asked, so you should be aware of the provisions. You can also be asked what is the difference between the present Act of 2025 or the bill that is there. So the provisions that I'm giving you right now has the provisions of the Act of 2005 as well as the bill of 2024C. Okay, now disaster management Amendment Bill 2024, please see, when I'm mentioning the Act, remember we are talking about the 2005 provision. Whenever we are mentioning the bill, it is the bill of 2024. So that means in every provision, we are telling you what is being amended basically, right? So the first, preparation of disaster management plan. The 2005 Act provides for constitution of a National Executive Committee, the State Executive Committee to assist the National Disaster Management Authority and State Disaster Management Authority in performing their functions. In performance of their functions. Now see, a key function of the committee is preparing national and state disaster management plans. So the Act of 2005 provided that this is going to be an executive committee to assist the national disaster management authorities and the state disaster management authorities, which are going to prepare the plans for any disaster that takes place. Now what the bill does? The bill instead provides that the National Disaster Management Authority and State Disaster Management Authority will prepare the disaster management plans. So that means instead of having multiple hierarchies, straight away the NDMA and SDMA we have been told that you prepare the plans directly. Earlier what was there? We had the National Executive Committee, State Executive Committee to assist them in performing, and one of the key function of these committees. So at that time, the Act of 2005 said that the committees are basically responsible for preparing the plan. Over here, directly, the NDMA and SDMA have been told to prepare the plans for disaster management. So again, so we have reduced the hierarchies and the complexities in the preparation of the plans. So this is one of the first, this is what is being recommended in the bill. Now next, functions of NDMA and SDMA. Please see, when you see over here, we'll be realizing that from here, this is the bill of 2024, right? When we talk about Act, this is Act of 2005. So under the Act, we know that the NDMA and SDMA, that is the National Disaster Management Authority and State Disaster Management Authority, NDMA and SDMA, at their respective level include reviewing the disaster management plan of the government departments. They in the Act provided that setting guidelines for preparation of disaster management plans for the authorities below them and recommending the provisions of funding the disaster mitigation. Now these were the basically the functions of NDMA and SDMA. Now what the bill has done? The bill adds certain functions for these authorities at their respective levels. These include, these are the extra things that have been added. Taking periodic stock of disaster risk, including emerging risk from extreme climatic events. So in a way, we have realized that climatic disaster function has also been added to their jurisdiction. Next, providing technical assistance to authorities below them. Next, recommending guidelines for minimum standards of relief. Fourth, preparing national and state disaster databases. That means all the databases with respect to all the events that have taken place so that it can be analyzed and better plans can be prepared. The database will contain information on what? The type and severity of disaster risk, allocation of funds and expenditure, disaster preparedness and mitigation plan, and functions of NDMA will include what? Assessing disaster preparedness of the states and undertaking the post-disaster preparedness. So what we are seeing basically, extra functions have been added to the list of the disaster management, National Disaster Management Authority and the State Disaster Management Authority. So this is what is being done over here. That is the extra functions being added. So you can be asked in your papers that how is the bill different from the original act? So if you can mention few of these provisions, it will work. In the prelims also you can be added which among the following have been added as a functions by the or being proposed to be added as a functions under the National Disaster Management Bill of 2024. So this is the basic act. Okay. Next, one more thing, the bill also empowers National Disaster Management Authority to make regulations under the act with prior approval of the central government. That means there can be changes or regulations, certain regulations under the act can be made by the NDMA when the central government approves it. So again, more power has been given to the NDMA in this case. The bill approves. Now, urban disaster management authorities. Now, this is something new. The bill empowers the state government to constitute a separate urban disaster management authority for state capitals and cities within a municipal corporation. So that means this is a new aspect, because we realize that urban issues with respect to climate change and urban disaster are on a rise. So they said there is a need for a specialized or a specific urban disaster management authority, and this bill basically proposes for the creation of that authority, which was not present in the Act of 2005. So urban authority will comprise municipal commissioner as a chairperson, district collector as a vice chairperson, and other members specified by the state government. So this is a new body that is being recommended by the bill of 2024, which is urban disaster management authorities. Next, formation of state disaster response force. Please see, Act already had this provision, but there are changes made to this. See, the Act provides for constitution of National Disaster Response Force as specialist response to the disaster situation. So in case of certain, see, we have the national disaster aspect. Under the NDMA also we have the response forces, right? Under the state also we have specific response forces. But what the bill adds is something important for us. The bill empowers the state government to constitute a state disaster response force. The state government will define the function of SDRF. Now, this is again, we realize that the bill empowers the state government. Now, the state government will be empowered to constitute a force which was not already present in the Act of 2005. So, a little bit different. And the state government will define what the functions would be and what the terms of service would be. That means with respect to functions and service, it has been bestowed on the state government to decide. You decide whatever should be the functions and what are the terms of conditions for the people who are part of the SDRF, not the central government. Next, statutory status to existing committees. Understand this? Bill provides statutory status, that means legal backing, to National Crisis Management Committee and High Level Committee. So what the bill does, it gives statutory status to the National Crisis Management Authority and High Level Committee. Now see, the National Crisis Committee will function as a nodal body dealing with major disasters with serious national ramifications. So what is National Crisis Committee? In case at a national level a major disaster happens, this is a nodal agency which is going to deal with what the action should be and coordinate as a nodal agency, and it has been given a statutory status under this bill, would be given if the bill is passed by the bill of 2024. Now the high level committee HLC will provide financial assistance to state government during the disasters, right? So HLC will provide financial assistance to the state government during the disasters. It will approve financial assistance from the National Disaster Mitigation Fund. Cabinet Secretary will serve as a chairman of NCMC. The Minister of the Department will administer the control. Now in your preliminary examination, they can ask you the following provision with respect to the bill. They can ask you that there is a high level committee. The function of this committee is this, yes or no, because they might change the function and tell you, so you should be knowing the exact function. Then they can ask you that over here, cabinet secretary is a chairperson. They can ask you the prime minister is a chairperson of the high level committee. No, it is a cabinet secretary. So you should be very, very clear with respect to what the provision is saying. This is important, right? Next. appointment to NDMA. See, the Act of 2005 said that central government will provide the NDMA with officers, consultants, and employees as it considers necessary. That means the central government, based on its whims and fancies, will basically provide with the officers. Now, the bill instead empowers NDMA to specify the number and category of officers and employees with the previous approval of the central government, and NDMA may also appoint consultants as necessary. That means now it has the power itself to have consultants which were earlier dependent upon the central government's whims and fancies. So this is what is a bill that you should be knowing, important from the perspective of your civil services prelims as well as mains. Now comes the third topic, the missing spotlight on the urban local government polls. Please understand, in this particular article or the editorial, you realize that if you see from the aspect of the variety of topics being covered over here, no, there only one topic that is majorly covered is that there is delay in the elections at the level of urban local bodies, and that is being repeated again and again. So what we have done is, let us see a brief overview of the urban local bodies. What are the issues that are prevalent in that? And then we will see the aspect of the delay in the election that are taking place with respect to this editorial. That will be a holistic understanding of the urban local bodies. See, when I talk about local bodies, you very well know that there are two levels, or one is at the level of the rural regions, where is the Panchayati Raj institution that is there. Now, Panchayati Raj can be obviously urban and local also. At the urban level, we call it as a municipality or municipal corporations at whatever the size of the cities or towns are. So what we realize is that urban local bodies are in the urban regions, right? Now, introduction and effectiveness of the 74th Constitutional Amendment Act of 1992, we realize that by this act, the urban local bodies was basically given a constitutional status. Clear? Now see, addition of part 9A, that is the municipalities, the 74th Constitutional Amendment Act titled the municipalities, which encompasses Article 243P to 243ZG, deals with the issues relating to the municipalities. The first thing is that the municipality concept is a constitutional body, constitutional status by the 74th Amendment Act of 1992, which came into force on 1st June 1993. Now see, constitutional status to urban local bodies. The Act provides for a constitutional status to the urban local bodies, bringing them under the justiciable part of the Constitution. Now, we realize that once the constitutional status is given, the importance of these local bodies increases tremendously. That is why it was mandatory for the perspective of proper governance that the local bodies should also be given a constitutional status. Now see, if we see from the perspective of three types of local bodies, we have the municipal corporations at the cities or the larger cities level, municipalities to take care of them at the town level, and Nagar Panchayat in a semi-urban localities that we have. So these are the three types. Now coming here, Article 243W, empowering the state legislature, that is Article 243 of the 74th Constitutional Amendment Act, authorized the state legislature to enact laws to endow local bodies with powers and authority necessary for them to function as institution of self-government. Now please remember, when these bodies were formed, under them certain were compulsory provisions that these are the things that should be there in every urban local body, like having like the elections being conducted by the state election commissions. We saw reservation being provided to the scheduled caste, we saw reservation being provided to the women, and we saw election mechanism being held. So all these things were present as mandatory provisions, but along with it there were certain voluntary provisions which the state government can empower the local bodies as they feel is appropriate. That means the state government had the authority to even further empower the local bodies. That is why under Article 243W, the state government has a power, they can give more powers to the local bodies based on the state government's own understanding. Devolution of power and responsibilities. The 74th Constitutional Amendment, The state legislature made provisions for the devolution of the power, introduction of the 12th schedule. The act introduced the 12th schedule of the constitution, comprising the 18 functions related to the municipalities. Now that is something that we study in polity also. So overall, if you see, we realize that this is what the constitutional status to the urban local bodies was given, right? 74th Amendment of 1992 came into force in 1993. And over here, we realize that there are three types of urban local bodies that are present there. And with respect to this is a broad structure. Now, if you see, I've just mentioned over here the articles because this can be useful when you're preparing for polity. We realize that Article 243P, composition of municipalities, 243Q, reservation of seats for the scheduled caste and scheduled tribes, 243R, duration of the municipalities, 243S, dissolution of municipalities, 243T, power, authority and responsibilities of the municipalities, 243U, functions of municipalities, 243V, constitution of the State Finance Commission with respect to the municipality. So all these things are there which deals with the provisions of the municipality. Now see, the problems in general I have written first of all. What are the problems in general that the municipalities face? Urban municipalities, so which are in the urban region. Limited ULBs, urban local bodies, first of all, because it will be used again and again. Urban local bodies, right? Limited financial resources. Please understand, the urban local bodies are very badly dependent upon the grants from the state governments because they themselves are not able to collect the amount of taxation that they should be collecting, because we realize that even the Administrative Reform Commission say that they are just working at a 20% efficiency, even less than that. That is why the amount of tax that can be collected from the people is not collected. So due to the limited revenue raising powers of the urban local bodies as well as low level of tax collection, revenue generation in many urban areas is very low. That is why they're dependent on the state government. Second, lack of autonomy, limited autonomy to the urban local bodies. Please remember, if you see, the district magistrate is there at the district level controlling the district administration. And we realize that the state government were given the power under the Constitutional Amendment Act of 1992, 74th, where the state government can give extra powers to the local bodies. But the state government itself will not give the powers because it doesn't want to let loose the power going into the local bodies. And the district magistrate will also prevent that from doing that. That is why what happens is, the autonomy with respect to the functioning of the local bodies is lacking, and then unnecessary intervention from the district authorities also takes place very frequently. Next is parallel bodies. In some states, there is some ambiguity in the functioning of the urban local bodies as parasital bodies, making municipal governance very remote and inaccessible. What happens is that in various states, we realize that along with the urban bodies, there are other bodies that are running. And they basically contradict the functioning of the urban local bodies. That again leads to multiplicity or duplicity of the functioning, and that creates a lot of problems. That is why please realize that these parallel bodies that are existing is a problem with respect to the governance that takes place. Limited human resources. Urban local bodies suffer from the shortage of skilled or qualified persons. When that happens, automatically we realize that proper functioning cannot be met. Next, fifth, poor infrastructure. Many urban local bodies face shortage of infrastructure such as roads, water supply, sewage system, which can limit their ability to provide basic services. Next, political interference. Urban local bodies are subject to political interference which can affect the independence and neutrality of the decision making that takes place. That is why we realize that at the local level also, the political leaders or bosses might intervene in the functioning, and that again leads to inefficiency or lack of proper functioning of the local bodies. Seventh, limited public participation. Urban local bodies face lack of public participation in the decision making. Because see, again, this is relevant with respect to even the state administration and the central government also, where once the elected representatives are elected, they are the ones who are dealing with everything. So people are directly not involved in decision making, which actually should be when you're talking about the local bodies. Eighth, lack of capacity. Many local bodies lack the capacity to effectively plan, implement and monitor the development projects. So we realize that proper accountability, proper dealing with the aspects of let us say auditing, these things are lacking over here. And because of that, we realize that the capacity building or improvement in the efficiency of the urban local bodies lack. When that lacks, what is the outcome? The inappropriate functioning basically is the outcome of that. So as we move ahead, what are the important issues that were highlighted in the editorial itself? That becomes important. This is another thing. What the editorial also highlighted is that greater than 60% of the urban local bodies see delay in the election. That means when the elections are delayed, how will the functioning will take place? Not be able to take place. That is a CAG report. Issue of accountability due to non-election, because when the elections are not taking place, automatically the urban local bodies will not function. And the issue that arises related to drinking water, sewage and all, they are not resolved. And who is accountable for that? It is the state government who should make sure that the elections are held on time, but they are not held. Then delay in the delimitation. Delimitation is basically the constituencies or where the wards are there. Wards are basically like we have the constituency at the level of the state, or for that matter a member of parliament. We have wards or the regions for where the local level body candidates are basically fighting elections. Those delimitations are not done at a repeated basis or a continuous basis, which should be done. That further leads to the delay from the state election commission to take or conduct the election. That is what is the problem, right? Next, prelims topics. Bangladesh delegation likely to visit Vijay Divas. Now, what is Vijay Divas? Please see. Vijay Divas is a national day to remembrance celebrated on the 16th of December every year. It honors the Indian armed forces and their role in Bangladesh Liberation War of 1971. That is basically Vijay Divas. The day signifies India's military triumph over Pakistan, leading to the creation of Bangladesh and the surrender of greater than 93,000 Pakistani soldiers. Now, that is what is Vijay Divas. Now, these are certain details. I think it will be useful for you in a sense that brief idea in a summarized form. See, name of the day is Vijay Divas, day of celebration, 16 December. Significance, it commemorates the India's victory over Pakistan, war of 1971. We have year 1972, first time it was celebrated in 1972. Historical context makes the surrender of 93,000 Pakistani soldiers. Duration, 13-day war from 3rd December to 16 December. 16 December, we had one. Next comes main objective to honor the courage, valor and sacrifice of the Indian soldiers. Next is reason for the war, to support the Bangladesh liberation movement and against the West Pakistan's oppression of the whole country. There are massive rapes, murder being committed by the armed forces of Pakistan against the East Pakistan of that time, which is now Bangladesh. Result of the war, creation of a new nation of Bangladesh, formerly East Pakistan. Next was military leaders. Field Marshal Sam Manekshaw led the Indian Armed Forces to victory. Number of Pakistani troops surrender, 93,000. Key operation, Operation Trident and Operation Python. We'll see that. There were two operations which were very important with respect to the win over the Pakistan. That was Operation Trident and Operation Python. Main forces, Indian Army, Navy, Air Force, all the three were involved. Celebration activities, Rath Link ceremony, parades, cultural events, Amar Jawan Jyoti again remembered over there. Status, National Observance Day, not a public holiday. Key takeaways, symbolizes India's strength, power and support for the democracy. Now comes the two operations. Please remember, one was Operation Trident, other was Operation Python, which I had mentioned. You should be doing a little bit idea, because instead of asking Vijay Divas, they can ask you, these are associated with which day. So over there, these names should be present in your mind. See, Operation Trident is basically launched by Indian Navy on 4th December 1971. This operation targeted at Karachi harbour. It resulted in sinking of several Pakistani ships and destroyed their fuel storage facilities, causing a significant setback to the Pakistani naval strength. Operation Python, this was a follow-up naval operation launched on 8th December 1971, with Indian Navy forces further attacked the Karachi harbour, inflicting severe damage. The success of Operation Trident and Python basically established the Indian Navy's supremacy in the region. So Operation Trident was done, sinking the important ships of Pakistan, and then a follow-up operation was Operation Python. These are all related to the Bangladesh liberation movement that basically took place. Significance, tribute to the soldiers, victory to democracy and freedom, symbol of India's military power. Let's move ahead. Then officials on the toes as tigers train Jharkhand, Odisha, Similipal. So you should be knowing where is Similipal. If you see the map of India in Odisha, if you go here, this is the region where Similipal is. So from the map perspective, this is something that you should be knowing. Next, it is Similipal Tiger Reserve. Please understand, it was designated as a tiger reserve in 1956, included in the Project Tiger, and declared as a biosphere reserve in 1994. It is recognized as a part of the UNESCO's World Network of Biosphere Reserves since 2009. It forms a part of Similipal, Kuldiha, Hadgar Elephant Reserve, Mayurbham Elephant Reserves, which encompasses 3 protected areas: Similipal Tiger Reserve, Hadgar Wildlife Sanctuary, and Kulidha Wildlife Sanctuary. So something that you should be knowing are closely associated with the Similipal Tiger Reserve. Location: situated in the northern Odisha's Mayurbham district, at the eastern edge of the Eastern Ghats. Now this is something with respect to location. Tribe: home to the Erenga, Kharia and Mandikidas tribe, is important with respect to this particular reserve and region. Unique features: the only place in the world where melanistic black tiger are found. Only place in the world. Fauna includes leopard, gaur, elephant, langur, barking deer, spotted deer, sloth bear, mongoose and squirrels. Then we have Salar, the Uyuni. This was a photograph there. This is basically referred to the salt flat or salt plan that is there, right? Now this is basically the description. We'll see, this can be asked. See, we are talking about Salar de Uyuni in Bolivia. So what, understand, this is basically a salt flat. What is a salt flat? Large areas which are covered with salt. Salt flat is a natural landscape in which large areas of flat land are covered by salt. And over here, perhaps the world's most well-known salt flat is Salar de Uyuni in Bolivia. It is the largest in the world of its kind, and it contains more than half of the planet's lithium reserves. It becomes important because we want lithium with respect to batteries. In Bolivia can be an important resource for us if we have good diplomatic relations with them. Now, a salt flat forms from a natural water where water recharge rate is lower than the evaporation. The water recharge that is taking place is at a lower rate than the evaporation taking place. So automatically the evaporation will take place, and what is remaining in the water is a salt that will again get deposited. So that is what is the concept over here. They reflect sunlight strongly and thus appear bright, because the salt is there that reflects the light, and you can see some shiny thing in the salt flat. That is what is being there. Okay. Next, formation of the shapes. See, where there have been various aspects with respect to how they are formed. See, the salt on the surface is influenced by the salt flowing through the soil below. Now, the water that is flowing basically has large amount of salt in certain regions. So what happens? The salt penetrates deeper into the soil exactly below the ridges and shallow under the flat areas. Now what happens, as we realize that as the temperature is high, evaporation process is high, so again there's a concept where through water again little bit rises and the salt is basically pulled up, and because the evaporation is high, the salt layer is deposited basically on the soil, and that remains over there. So again, an outcome is that the rate of evaporation that is taking place is much more at a higher rate than the recharge that is taking place. But we realize if you go ground level, you see the water would be still flowing in the ground level, which is still having a large amount of salt. But because of the capillarity action that takes place, as you see in the plants, capillarity action is there, water is pulled up. Similarly, when the evaporation is high, the water that is present in the groundwater region of this particular region is pulled up. When it is pulled up, it comes to the level of the soil, but the evaporation is very high over there. So what happens? The water might evaporate and what is remaining is a salt, and it leads to the formation of a salt flat. Okay, multiple choice questions. Question number one. Question number one, you can pause the video while seeing and you can attempt the question. Question one, options, answer. Question two, options, answer. Question three, options, answer. Question four, options, answer. Question 5, options, answer. This was the analysis of the Hindu from today's newspaper. Hope you liked it and enjoyed it. We'll be meeting tomorrow and continuing the lecture. Take care and Jai Hind.